call the fourth case on this morning's docket, case number 119027, in the matter of Gregory B. Bloom.
Good morning. Please the court. Penny Moylan appearing on behalf of the Disciplinary Administrator's Office. Chief Justice Nuss, I'd request 5 minutes rebuttal.
5 minutes is granted.
Thank you. This is an original case in discipline. It's arising from Mr. Bloom's representation of two different but related clients and two different but related district court cases in Johnson County. Mr. Bloom filed exceptions to the hearing panel report, and he appended 9 attachments to those exceptions. At the outset, I'd like to just say, pursuant to In re Gershotter 270 Can 620, these exhibits should not be considered because they were not presented before the hearing panel. Mr. Bloom raises one issue in his brief, and he titles that a 1-year suspension is too severe a sanction for the rule violations. However, Mr. Bloom proffers several arguments as to why there was not clear and convincing evidence to support the rule violations. So I'm going to briefly address the evidence that supports the rule violations, and then I'll talk about the sanction. Although it could be argued that the underlying litigation that gave rise to these complaints is somewhat complex and convoluted, the disciplinary case is quite simple and straightforward. It arises from 5 different factual scenarios. 3 of those factual scenarios are laid out in district court opinions, and I'm going to talk about those briefly right now. The first 2 factual scenarios are addressed in Judge Vano's July 1st, 2016 memorandum opinion and order, and it was denying the respondent's motion to alter or amend his judgment granting sanctions. That opinion by Judge Vano was forwarded to our office as a disciplinary complaint, and it's found in the Record on Appeal, Volume 3, pages 8 through 16. And there are 3 findings that I think are relevant to the rule violations. First of all, Judge Vano found that Mr. Bloom intentionally and wrongfully failed to produce a March 27, 2012 email in response to a lawful request for production of the same. Judge Vano also found in that opinion that there were various reasons given by Mr. Bloom, but at the very least, it appears that Mr. Bloom did this to just try to embarrass a witness at a deposition. This finding, which was found to be factually supported by the hearing panel, constitutes clear and convincing evidence of the 2 following violations. 3.4d, which is failure to make a reasonably diligent effort to comply with a legally proper discovery request, and 4.4a, which is engaging in conduct that has no means other than to embarrass a third party. The second finding found by Judge Vano is that Mr. Bloom provided material statements of false fact to the court in giving his reason for not producing the email. As you guys can see in the brief, Mr. Bloom gives various reasons as to why he didn't produce that email, but it's very important to note this. Mr. Bloom argued that in the hearing on the motion for sanctions that he did not have the email in his possession until 1 week before the August 2016 or 2015 deposition. However, in this motion that he filed to alter or amend the judgment, he said, I had the email in June of 2015 when I responded to the request for production, and it was opposing counsel's own indolence and own neglect that they didn't follow up on it when it wasn't provided to him. So Judge Vano, in his decision, when he was denying Mr. Bloom's motion to alter or amend, said, this is a false statement of fact. You said that you didn't have it until August, but yet in your motion to alter or amend, you said that you had it at the time you responded to the discovery request. This finding also is clear and convincing evidence that Mr. Bloom violated 3.3a, candor toward the tribunal, and 8.4c, misconduct involving dishonesty, fraud, deceit, or misrepresentation. Lastly, Judge Vano's July 1st, 2016 opinion noted the differing versions of facts that Mr. Bloom had given for not producing this email, and he made the following sort of comments about the motion to alter and amend. He said it was difficult to address, it was inconsistent, it was disingenuous, it was tangled web of irrelevant ramblings and vagaries. The hearing panel found that Judge Vanos' findings established clear and convincing evidence that actually filing the motion to alter and amend the judgment violated 3.1, filing a frivolous pleading. So the third factual scenario is laid out in the second Johnson County District case, and it is in an opinion by Judge Hauber. It's a September 13th, 2006.
Excuse me, counsel, just before you continue, I want to return to the one you just mentioned. You're talking about a motion to alter or amend, or the motion to set aside the judgment was the frivolous pleading. Which is it?
Both are.
Okay.
But I'll get to that.
Okay.
The hearing panel itself found that the motion in the, I'm going to call it the 2014 Johnson County case, Judge Vanos' case, that motion to alter or amend the order granting sanctions was a frivolous pleading.
Okay. Thank you.
Sure. Now I'm going on to the second case, which is the 2012 Johnson County case that Judge Hauber presided over. In that case, Mr. Bloom filed a motion to set aside a stipulated journal entry of judgment that had been filed or entered 3 years earlier. Judge Hauber granted a motion for sanctions against Mr. Bloom and his client, and in the course of that opinion, which is found at Exhibit 27, which is in Volume 3 on the Record of Appeal, he found that Mr. Bloom's motion to set aside the stipulated journal entry was in defiance of common sense, not factually or legally supported, patently frivolous, and a delaying tactic. Judge Hauber's decision, which the panel also found was factually supported, constitutes clear and convincing evidence of a 3.1 violation and also an 8.4D violation, conduct prejudicial to the administration of justice. The last two factual scenarios happened in a March 22nd, 2016 deposition, and they are not disputed by Mr. Bloom that they actually occurred. The first one is Mr. Bloom called a videographer a Nazi, and the second instance is when he flipped off a gentleman named Mr. Willis, who was a representative of the bank. The hearing panel found that this is clear and convincing evidence of a 4.4A violation, means that have no substantial purpose other than to harass a third person. That leads us to the appropriate sanction in this case. At the hearing panel, I requested a 1-year suspension with reinstatement hearing. That is the discipline that the hearing panel recommended, and I stand upon that recommendation today. The hearing panel found multiple aggravating factors and 2 mitigating factors. I would just say to the court today that this is serious misconduct for anyone, much less a solo practitioner. It's a serious misconduct and it's a serious sanction. 1-year suspension is serious for any practitioner, much less a solo practitioner. I argue that a reinstatement hearing is necessary in this case because, as evidenced by Mr. Bloom's briefs, he is completely unaware of why his conduct in this case is a violation of the rules or a problem in our legal system. I have some serious concerns about this apparent complete lack of awareness and believe that a reinstatement hearing is necessary for Mr. Bloom to establish several things. One, that he understands that he violated the rules. 2, how the effect that his behavior has had upon the administration of justice, upon his legal colleagues, upon the legal system, upon the profession. And 3, that he can establish that he won't resume this behavior if he is allowed to practice law again.
And just backing up one more time, returning to the point, you're telling us the panel did find frivolous 2 different pleadings.
That is my understanding, yes.
Okay, all right, thank you. I think the one that his brief focuses on is the motion to set aside.
Correct.
Okay, thank you.
Do you have any further questions? Thank you, counsel.
For the record, I'm Greg Bloom, Gregory Bloom legally, and I'm the respondent herein. Let's go first to, we briefed the issue of how wrong the judge was on his sanction motion. He started with the fact that he blamed Mr. my client, the mister, for evading the debtor's exam and then taking bankruptcy the next day. He was factually wholly wrong on that. He did not. That was the partner who did that. Number two, that stipulation, later, the attorney, that order, the attorney, after the mediation that settled everything, after they lost, the bank did, and MF lost the bankruptcy adversary against Mr. LO. Okay? I call this loser's lament. He stated in front of the panel that he forgave it. It's like $3,250 because it would be too hard to get it collected. Well, considering the fact that he admits and is proud of the fact, I guess, that he spent $250,000 at $3.25 an hour, that charts out to 745 hours to lose the one time they actually went to court. The second case, which had been, let me get back to this. And he made the ridiculous statement that since it might be difficult to get it collected, that's why they forgave it. Now, they didn't send me a 1099, so they committed tax fraud. But all you do to get a judgment sanction, a sanction collected, is you tell the judge that gave the order, Bloom's not paying it, and that judge, at least in my experience on the eastern half of the state, would say, Greg, what kind of insulin do you use? Because you're going to jail at 5 o'clock if you don't pay my order. So that was a silly, false statement. They forgave it because they didn't want to get sued.
What does that have to do with any of this?
That's the Judge H sanction motion.
What does that have to do with whether you've had violations? Any of the things that you just told us, what does any of that have to do with whether you engaged in the conduct that violated the code?
Okay. Two distinctions. One, this is supposed to be protecting citizens of the state of Kansas. Ms. Moylan has admitted she did not talk to my clients. She gave an opinion that she doesn't think they're happy with the result. But I would think the citizens, not the lawyers from another state, would be the ones that you want to talk to. I can't find one case in all the reported decisions, at least in the last 40 years, didn't go back too far after that, where the clients weren't part of the victimhood. No, my clients were exceptionally happy because they had been abused and carried on by these people. Now, the other thing she forgot to do is we're all obsessed with the July 1st, 2015 order. What she doesn't mention is that on July 7th, 2016, in front of that judge, we had a pretrial. And at that time, His Honor pointed out that Mr. MF had neglected again to follow the punitive damage statute. He had violated the law twice at the onset of the case by pleading for punitive damages twice, once against LO, once against GO, right? In his counterclaim and cross-claim. Filed it, took advantage of the, no answer, you can do another one. Did it again. He was sanctioned $1,000 for that. Then we go 2 years forward, and the judge on the transcript, document 119, says, no, you're not getting punities. Told him 3 different ways. You did it again. It's the final pretrial. Today's the final pretrial. It's too late. Apparently, MF thought what he would do at the trial conference, what we do in Johnson County, most of the judges have an instruction and motion to eliminate hearing the Friday before the trial. So at that point, Judge V took note of that and said, no, you're completely out of luck on the punitive damages. Not going to happen. He also raised a problem that he did not see how FMVO was going to make their case for fraud.
Counsel, I have some questions.
Okay.
I'm just going to ask if I may, before you finish your presentation, and this now might be a good time to tell us, do you believe that any sort of discipline should be imposed against you?
I believe my characterization of the videographer who was 10 feet away was inappropriate, as the man who was raised by two Marines that were old enough to be my uncles, 4 years at Jesuit High School where they felt free to give corporal punishment. I know how to take my punishment.
So
The problem is when we had
The Nazi statement is what you should get some kind of
yes,
sanction for?
because the other statement is a lie. That look.
and if you are agreeing that you made that statement to the videographer,
Yes.
and you're not agreeing to any other sanctions as we stand here today, what do you believe should be the discipline imposed for that statement?
I already said, because when that was set for hearing, they didn't bring, I forgot his last name, that young man. They brought their new $500 an hour bankruptcy lawyer. I believe Judge Vano is a fair and disciplined man, and if he had brought that kid and he said Bloom did it, I think he would have sanctioned me and I would have had to have taken it because it was an inappropriate comment.
It's before us today. My question is, what do you think would be an appropriate discipline for your admission to making that statement?
Oh, a written apology, and again, I like donating to children's hospitals. I'll donate $500 to St. Jude's is my favorite.
All right.
But
Justice Byer, I think I cut you off. No.
Okay.
But in terms of the other comment, that gentleman swore what he did was he turned to his counsel and said, I'm getting real sick of this low-rent guy. And I had learned that term from my client, Mr. L.O., that was his term of pejorative. He stated in front of the panel that no, when my client asked me whether she should stay or whether we could come back, he claims under oath that he said, oh, come on, Greg, we got a right to take the deposition. A witness, not the lawyer. That simply didn't happen. Take my word for it, as somebody practiced 45 years. I don't think that was appropriate at all. And I think it's perjury because no witness has a right to intrude in an attorney-client privileged communication. So it's if you don't want to take my word for it, you can look at the fact that is so counterintuitive. I don't know if anybody else here has ever had that happen, but it'd be like a witness popping up in the middle of a trial and saying something. It simply didn't happen. If I should get a sanction for flipping him off silently that isn't reflected on the record, that's up to you guys.
Are you saying you did or did not do that?
No, I did flip him off because he said that. Fortunately, my client at the time was like 75. She had pretty good hearing, but she was afraid of him. He had, on all those depositions, he would sit 4 feet across from her on the table and stare at her. She felt intimidated by him. She didn't like him. So that's what happened now. Now, one thing I need to mention is this process has taken.
I do have one fast question. Okay. Is the Chambers rule of Judge Hauber that you relied upon in filing your motion to set aside
Yes.
a part of the record before the panel?
I don't recall.
Thank you.
What was wrong, if we want to transition to that, I'm watching my time, to that, his statement was so wrong because they had established this silly volume foreclosure rule to grease the skids for all those mortgage-backed securities and foreign banks and stuff. But that's not what he used. On valuing the real estate, the collateral was 3 parts, line of credit, the tortilla factory down Beverly in Johnson County, and the real estate upon which it sat. So he decided that that's the way it goes. No, Judge Carlin, she doesn't need my endorsement. She's great on business stuff. So she said no. The bank, in fact, the bank officer who sat in on every deposition, he liquidated that stuff, and he's the one that Judge Carlin, page 3 of her 24-page decision, she agreed by the end of the first 10 pages that my worst fear was realized, and that is L.O. Doesn't know what he's talking about. I think he's got, I really don't want to slam the poor man, but I think he had short-term memory loss. You don't remember what happened 2 days ago, but you can't remember what happened in 1965. And so she decided and ruled that he had virtually no credibility whatsoever. But then on page, I think it's 3, the footnote says, the witness they brought was the wrong witness. The gentleman that they tried to depose, maybe drive up to Kearney, Nebraska, he was the proper loan closer. He was the proper witness. So Judge Halvers' reliance on all that I was trying to stall, make them prove their damages again, was simply not true. It's also a little bit silly, in my humble opinion, to argue damages when you lose Carthaginian defeat on liability. She found that they did not prove their case. With 3 lawyers on my impaired client and my humble services, they couldn't prove their case. That was August 20, I think the decision was like August 25th. That other case in Missouri where they tried to take away their only exempt asset, they dropped that case the next day. But the thing I have to mention is I've had lots of fun and challenges in 45 years, jury trials, meet some really great judges like our late friend Judge O'Connor or my late friend Judge Walton, Wyandotte County, every place, Kansas City, Missouri. I'm retiring in, I'm hoping June 10th, my 69th birthday. It's not a mitigating factor, but I've been diabetic for 27 years. Let's see. Then I got the chronic lymphocytic leukemia, which I still haven't overcome. Heart surgery in 2008, and I think I had pancreatitis attack in there. I'm not mitigating. I'm lucky to be here. I wake up every morning. I've enjoyed practicing law. I just don't suffer fools gladly. Not you guys, not Penny, but everything that happened. If I can finish with this pretrial that they simply don't remember, right? The judge at that time also said, he put the infamous document, this email from JSS, the witness, the former employee at the bank. He said that was back in. We should brief that issue for the trial. Then I can safely predict the Chiefs ain't winning the Super Bowl this year based on my 45 years, based on, for example, the first deposition of Ms. O, 5 foot, 75-year-old Mexican-American lady, very proud, good citizen, good American. He said to her 7 times in 45 minutes, I'm not trying to trick you. I had no, that convinced me, plus other things. He told me later on he didn't need JSS because he had a bill collector.
Before you sit down, I want to understand, you mentioned that you're retiring
Yes.
in June 10th. Is that certain retire? You said, I'm planning on it. Or
Yes.
Is that a certainty that you're retiring June 10th?
Yes.
And does that mean you're not going to engage in the practice of law, or you're going to do it part-time, or what are you saying to us by that you will not be, what happens on June 10th?
Well, I turned 69, and that sounded too cheap. That way I don't have to spend money and take another 10 hours, 12 hours of, I haven't been soliciting clients for a
So
while.
you're going to retire, you don't plan on completing your CLE, and you're done?
Yes.
Okay.
Time for a new career. I plan on March 1st, for example, gardening, and besides my family and my wife for 40 years, all that stuff, I like gardening and golf, and I've been so busy the last 20 years. All I'd like to do is, if it ever stops snowing, is to be in my garden on July 1st. Now, to be fair, I've got one case, this poor gentleman in back, that has had 2 lawyers. One of them we won't name by name, but I can call him Thomas Jefferson, and another one that abandoned a case. The U.S. attorney referred him to me a couple years ago, and I don't know how long that's going to take. I have 2 other cases that I just can't, I'm not going to neglect them. Those are the only 2 cases. I'm not taking phone calls, I'm not taking referrals, I'm not doing anything else. But 45 years was enough.
So you're gonna resolve those cases even if they take longer than June 10th?
Depends on what my clients want me to do, but it's going to be difficult to transition to somebody else.
Counsel, I see you're out of time. Would you like 30 seconds to wrap up, or do you believe you've made your points?
Chief, do you mind if I ask one question?
All right.
Counsel, we continued this hearing because you were going to seek counsel. Can you tell us what your efforts were since that continuance
Well,
to
after
do
I
that?
Given the unhappy meltdown of my other counsel, it would have been thousands and thousands of dollars. Nobody was really interested because it was too late. And
Did you ask anyone to represent you in this matter
Uh,
since you
no.
asked us
No.
for continuance for that purpose? Thank you.
Any further presentation?
No, like I said, I think this time, I do have, this will take 20 seconds, I believe. Back on June 15th, the problem with the bankruptcy case is LO's lawyers faded on him, 3 different ones. I hadn't done anything in bankruptcy court in an adversary in like 30 years. So I got suckered into that. But he filed using a different lawyer, I don't know, June 5th or something. We had a hearing out on June 15th, 2015. And Judge Vano told him he wanted a stay of some kind because the co-defendant, the husband, was in bankruptcy. And the judge, and he wanted to file, he threatened the court that he was going to file an interlocutory appeal. Judge Vano said, "You're done. You've had your say. I'm ruling at this point in time. You can then file an extensive motion to reconsider my ruling if you want to." You seem to be able to do that. And I think maybe it has something to do with we are going to appeal regardless, and we're going to incur a lot of expense. It kind of has the feel that you like incurring a lot of expense.
Thank you, counsel.
I'll be very brief. Justice Beyer, just 2 answers to your questions. One, the hearing panel did make 2 3.1 violation findings on both the motion to alter and amend the judgment, and then also Judge Hauber's the motion to set aside.
So here's my question. If we were somehow to find that there was a good faith basis for the motion to set aside based on the Chamber's rule, if we were to get there, and which would say it's not frivolous, there was some good faith argument to be made, maybe a weak one, but good faith, there's still a violation of filing a frivolous pleading on which your recommendation for sanctions would depend.
Yes.
Would your recommendation change at all?
No.
Thank you.
And then your second question was regarding the chamber rule. Was it an exhibit before the hearing panel? And yes, it was. Mr. Bloom actually submitted that as an exhibit, so it's in the respondent's exhibits. Lastly, I just want to say this. Mr. Bloom makes a lot of arguments in his brief that are addressed in the brief, and his characterization of some opinions and what actually happened in the case obviously is contested by me, and I put it in there. I would like to just address one out of all sense of fairness for the record before this court, and it involves his allegation that Mr. Willis and myself somehow committed perjury by Mr. Willis saying that he was flipped off by Mr. Bloom after he just said, "Oh, come on." And Mr. Bloom has said repeatedly that Mr. Willis called him a low rent guy. I just would like the record to reflect and the court to take note that there were 3 witnesses at the hearing that testified. One was the videographer, who has nothing to do with this case. And he testified exactly how Mr. Willis and the counsel for the bank testified, that during a break in the deposition, they were talking about whether Gloria could continue on with the deposition. And she said, "Yes, I think I can." Mr. Bloom responded, "Don't do that, they'll just torture you." This is during a break in the deposition with everyone present, and Mr. Willis just said, "Oh, come on." And that's when Mr. Bloom flipped him off. There are 3 people that testified to that, and I just wanted to say that for the record before the court today, to hopefully stand in defense of Mr. Willis in these proceedings. Again, I just stand on a recommendation. The rule violations were established by clear and convincing evidence. We believe a 1-year suspension with a reinstatement is the appropriate sanction in this case.
Any questions? Thank you, counsel. I thank both of you for your arguments this morning. Court will take this matter under advisement